Alex here with part 17 of the My Docket series on child custody and visitation. If you haven't seen part 0 of the My Docket series yet, take a look at that video. That is the video with the detailed disclaimers and the underlying purpose behind the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. My ex's parental rights were terminated. Number two, the nutshell version of the purpose of this series is to create one gigantic example for my viewers of my high conflict child custody dispute from beginning to end in chronological order. The other thing that I'd like to mention as a side note is if you are not getting all of the notifications from YouTube in your email, that is because you have not clicked on the bell notifications button. If you are just a subscriber, YouTube is only going to notify you of some of the updates on the channel, not all of them. If you click on the bell notification, YouTube will notify you of everything that is uploaded. So we left off in part 16 with a case management conference, and more importantly, an interim order after that conference. It is a temporary order. If you haven't seen the video Temporary Orders, I highly recommend you go and watch it. In that order, the judge scheduled what he did was he set a new visitation schedule, and he put a trigger date in his order for when that new visitation schedule was to take effect. Between the time of the case management conference and the date that the new visitation schedule was supposed to trigger, my ex made an appearance or maybe two appearances at an exchange an hour late. She claimed that the judge allowed her to show up at 9 a.m. instead of 8 a.m. And what I responded with was, you requested that, your attorney asked for that, but the judge did not order it. So you're supposed to be here at 8 a.m. And my response to her showing up late after talking to her and telling her, please comply with the court's order, and I'm pretty sure she did it twice. In fact, when we go through the motion, I'll take a look at the details and we can actually talk about that. But I responded by filing a motion to hold her in contempt of court because she was willfully violating the court's orders. I have a whole lot more to talk about with respect to the dynamics behind her action, because this was the first time she was testing her boundaries. And what I mean by that is she's been testing her boundaries since forever. This is the first time she was testing her boundaries with the court system, with the legal system. And this is a milestone for her. And there is a lot that I can talk about, but what I'm going to do with regards to her attempts to exploit weaknesses in the system and how the court's response is going to affect her going forward, what I'm going to do is deal with that when the court enters its order. So in the future, I'll do another video in the My Docket series where the judge enters his order on this motion that I filed. And at that date and time, I'm going to go into a lot more detail as to what I think was going on behind the scenes, both in her head and in the judge's mind. So at this point, I think we can go ahead and take a look at what I have filed. Here we have the motion for order to show cause. It's a form order, so I'm still using SelfHelp Forms. This is something I continue to talk about in each video that I find one of these. And as I've mentioned in my previous videos, I do stress now and plenty of times prior the importance of transitioning to custom papers and other filings. And that hasn't occurred yet, but I do want to bring that up because anytime one of these SelfHelp forms pops up, it's important for me to let the viewers know that even though I did this back in 2008, I don't recommend it if you're in a high conflict child custody case. You do need to ultimately find a way to stand out from all the other parents who are representing themselves, because in your situation with your high conflict ex, you're going to end up going back to court so many times that it's crucial that you do not look like one of the other parents who's just filing a whole bunch of papers and pleadings randomly without knowing what they're doing. Anyone representing themselves isn't going to know what they're doing initially, but hopefully with some work and some effort and researching court rules and statutes, you get closer. Not necessarily as good as an attorney, but you get closer and closer over time. And it is something that you just have to mentally prepare yourself for, because in a high conflict case, you have only two choices. Number one, give up on your child. Number two, learn how to litigate. So let's scroll down. As with all of these filings, I'm only going to cover what jumps out at me as important for the viewers. You will be able to download these documents down in the description below, and of course, if you have any additional questions on things that I haven't covered in the video, you can post them down in the comments below, and I can go ahead and respond. Right here, I'm seeing the first paragraph gives the pretty typical information that you'll see in the first paragraph of any motion. It's who is filing it, and in this particular case, because it's an order to show cause, who violated the order. In this case, it's my ex, and the date that the order in question was entered. So according to the order, she was required to adhere to the visitation schedule. Interesting. So this is a technicality that I do want to talk about. That is kind of the purpose of the series, but there is a reference here to the visitation order entered by the domestic master, and I wonder if this district judge has the authority to enforce that domestic master's order. I'm pretty sure that he does, but it's something that I didn't do any research on, because at the time I just assumed any judge can do anything. And just for my viewers, if this ever happens to you and you have an order in a domestic master's action, like a separate action, like a protective order action or a child support action, you may have to return to that specific court to try and get relief. And in this case, I filed this motion in the child custody action with the district judge that was presiding. I'm not sure, maybe this is okay, but I'm not going to do any research on it now, as I'm not actively in a lawsuit. I'm not trying to deal with this particular problem right now. And even if I did research and got the answer from my viewers, the answer that I provide could end up changing anyway, because the law does change, and case law and precedent is changing all the time. So I just want to point out to my viewers that that's something that jumps out at me, as I wonder if this was really filed in the appropriate case to begin with. I'm thinking it probably was, but I'm not sure. I mean, I'm just about, I would say, I guess 75% sure that that it was okay to do this. But like, for example, if the domestic master that entered the order was a child support master, I highly doubt that this would have been considered by the district judge. More likely than not, the child support master would need to review the motion for order to show cause, not the district judge. But these protective order actions they're just an oddball, because it's one thing is considered, whether or not to extend the order, and that's it. The domestic master's done, unless somebody else tries to get a, a protective order. Let's continue on. Okay, so yeah, here's the trigger date that I was talking about earlier. December 26th is when the visitation schedule in the interim order takes over. And I need to really talk about this a little bit too. It's not like my ex was confused, because some people might say, hey, maybe she was just confused. No, the December 26th date doesn't even set the visitation schedule according to what she is trying to say she thinks it's going to be now. She says, I'm allowed to bring him at 9 a.m., but the visitation schedule that triggers on the 26th of December is totally different. It requires her to drop him off to me at 3:30 p.m. So just in case my viewers were wondering, maybe she just got the dates wrong, or she didn't know when it takes effect. No, totally, it's an apples and oranges comparison. She was asking to move the time back from 8 a.m. to 9 a.m. and the judge decided to enter a completely different visitation schedule. And so, you know, I also talk about this in another video. It was actually a live stream called Narcissistic Pretexting. And one of the things that I didn't understand then, that I understand now, is that it's possible for somebody to know that they are doing the wrong thing, but play stupid in a way that allows them to defend themselves if they are called out on it at a later time. And the pretext here is, well, I thought he changed the schedule to 9 a.m. I didn't know. And so my response at the time was, okay, she says she didn't know, so I need to explain it to her. So of course we had all these text messages, phone calls, I'm sure there were phone calls and maybe even emails of me trying to explain to her how this works. And now here I am all these years later doing videos on YouTube telling people they know. They don't need you to tell them. They already know what they're doing is wrong. The thing is, they need a pretext to violate the court's order. They need something to use as an excuse just in case you call them out in court. And so I think that this was exactly what happened during, back here in December 2008. I think she knew that she couldn't drop him off at 9 a.m., but she did it anyway to try and trigger some kind of response from me. I guess some people call this baiting, other people call it setting you up. Perhaps she was trying to get me to send a crazy email, a threatening voicemail, something to show that I was a dangerous, scary, violent person. Maybe she was even willing to, have me call the cops on her and try to say I was crazy because I called the police over something so silly. I didn't take the bait. I didn't send any kind of crazy text messages, voicemails. I didn't call the police on her, nothing like that. I filed a motion, and that's what we're going through right now. I did not appreciate what she was doing. I felt she was going to exploit this and violate even more of the court's orders, and I felt that I had to put my foot down now or this was going to get a whole lot worse. And so my response was the appropriate response. Your ex violates a court's order, you take him back to court on a motion for order to show cause. Towards the end of this video, I'm going to talk about a couple of other things that I should have done to really bolster this, but for now, let's move on. So I'm saying here that I believe she's violated the court order by appearing late on December 18th at 9. And here's what I was talking about. She claims that the judge modified the schedule. I refuted it. Yeah, so the first time she showed up late, I didn't file it. And then, so then she showed up the next day and she did it again. Okay, so yeah, I told her, hey, don't do this again. You're violating the court's order. And then the next day she did it again. And I also, so actually I did do a pretty good job at covering my bases because I can see here that I told her, you know what, fine, you're going to take an hour out of my morning. At least give me an hour extra to keep him. And she refused. This is the difference between a normal parent and a high conflict parent. A normal parent will say, okay, you know what, that's fine. Since I dropped him off an hour late, you can keep him for an extra hour. That's what a normal parent will do. A high conflict parent, they don't want you to actually agree and come to an accord. They want to do something that triggers a response from you. And if she tells me, oh yeah, that sounds great, you can have him for an extra hour, she's not going to get a response. So if she wants to trigger some kind of reaction out of me, she needs to pull a stunt like this and not allow any kind of accord or agreement to occur. Basically, she's saying, I'm taking an hour, and no, you can't have an extra hour on the back end of the visit. You're going to have to, let me come get him. So she's trying to trigger a reaction or a response. This really underlines the fact that I was kind of thinking about gotcha litigation principles. I wanted to talk about this towards the end, but actually it looks like I was, creating a few outs for her. And I'm going to talk about this more in a little bit later, but let's continue on now. So this is what I was talking about earlier. The new schedule takes effect on December 26th. She willfully removed an hour of visitation on both dates. So that's 2 counts of contempt. So I'm asking her to appear in court and show cause why she should not be held in contempt. Here's the points and authorities that are just included in the motion. For anyone who's wondering what points and authorities are, please watch my video, Motions. I explain this in detail, and it's crucial that you understand. I declare under penalty of perjury that the facts... Okay, so this is the affidavit that's supposed to... I bet you there's a notary. Yeah, here it is. Okay, I should talk a little bit about this. This is not enough. This is a deficient affidavit. And what's really sad is it's a form. It's a self-help form. So the Self-Help Center was giving out forms that are actually not consistent with Nevada law. And I explained this a whole lot more in the video Contempt of Court. Please watch that video and try to understand that just because you're getting a form from the Self-Help Center does not mean that the form is consistent with the law. This affidavit is not detailed enough. The Supreme Court of Nevada and the legislature has a very strict requirement that all contempt motions include an affidavit, and the affidavit has to be specific, it has to list all of the factual allegations that constitute the acts of contempt. And in this case, this is just one of those generic affidavits that says, I declare under penalty of perjury that everything read in the document is true. That's not good enough. And a lot of people who were showing up with these motions were getting their order to show cause motions denied, not because their ex didn't comply with the or did actually comply with the order, but because this wasn't legal. It didn't have the necessary affidavit. So again, I don't want to go ahead and rehash what I've already talked about before. Please watch my video, Contempt of Court. I go into detail, at least with respect to Nevada, as to the mandatory requirement that an affidavit is included. A detailed, fact-specific affidavit is included. And I also wanted to mention one thing. Oh, it's jurisdictional. So what I mean by that is, this is not a problem that the court can get around. This is a problem that deprives the court of its authority to even hear or consider the motion. So anytime you have a jurisdictional issue, it's a lot more significant than any other issue because it goes to the authority of the court. It goes to the power of the court to even pick up the papers, look at them, consider them, and render a decision. It's the affidavit is what gives the court the power to even think about holding your ex in contempt of court. Without that, it's not so much that the court disagrees with you, it's that the court totally lacks any power at all to help you. That's the best way that I can explain it, at least in this quick 30 seconds that I took the effort to do so. Let's scroll on down. This is this comes with the self-help forms. This is given to my ex with the motion, I assume, and it just warns her that she needs to file a response to it. Gives the dates, the computation of time. Well, it's not actually that specific, but it does give some of the alternatives, like for example, if the document is by mail. Okay, this is the motion opposition notice. I've talked about this in previous videos. You basically follow the instructions, check the little boxes, and at the very end you determine whether or not you have to pay a filing fee. In this case, I didn't have to pay one. This is the affirmation. It's just one of those pieces of paper that's included in the self-help packets, and it just tells the clerk of the court that you have reviewed it to make sure there are no social security numbers in the filing. This is the index of exhibits. This is a document, a piece of paper that is required to be included after your motion or whatever other paper you're filing and prior to the actual exhibits themselves. If you do not include this, you will be turned away. At least I was. On many occasions, I was turned away for not including this piece of paper. There were some lucky situations where the clerk behind the counter had stacks of blanks, and actually now that I'm looking at this, it looks like one of those because it's a fill-in-the-blank index of exhibits. Later on, when I prepare my custom papers, I actually custom type the index or list of exhibits, but it looks like this is one of those situations where I forgot it, and the clerk just handed me one of these pieces of paper so that I could fill it out prior to filing. As far as I know, every judicial district in Nevada requires this. I'm not 100% sure. It may be different in some of the rural districts. It may be different in your state. There are also sometimes rules on the limits of pages. As far as I know, in the 2nd Judicial District Court, which is where I was litigating, there was no rule on the limit of pages. But in the 8th Judicial District Court, there is a limit. And if you exceed that limit, you have to actually put the index of exhibits separately from the motion itself. I have a friend of mine who did not do this, and the judge struck all of his exhibits at a hearing citing that rule that required him to file it separately. And actually, I'm wrong. The judge said that he didn't file it separately. And she said on that basis, for his non-compliance with the rule, she struck all of the exhibits, and because he didn't include any exhibits because she struck them, she denied his motion. But in reality, he did file it as a separate A separate document, he did comply with the rules. He filed a notice of appeal, and the Supreme Court reversed the decision of that judge. But that just goes to show you, had he actually not complied with the rules, even though she said he didn't, he actually did. But had he actually not complied with the rules, that could have really cost him his motion. And by the way, after the Supreme Court reversed her decision, he went back to court on remand and got joint physical custody, which is what he wanted. But that just goes to show you little teeny tiny technical details like this that seem like they don't matter sometimes will blow up in your face if a judge decides on that particular day they're going to hold you to that technicality. Actually, before I move on, I'm going to mention something. I'm actually not going to go over these two exhibits because these are papers that have already been filed. If you want to download this document, in the description below you'll find a link for it, and you can download it and you can review the exhibits yourself. But I'm not going to cover it in the video because I've already covered it in 2 separate videos. If you want to see my analysis on the interim order after case management conference, please watch part 16 of the My Docket series. If you want to see the extended protection order against domestic violence, please watch part 9 of the My Docket series. So I'm going to just review one more page because I want to show you guys what one of the dividers looks like. And here it is. It's just a single piece of paper that just says exhibit, and then the number on it. And it looks like in this case, the clerk had to help me out again because this is it's just got a blank line for me to write in the number 1. So I probably showed up with my exhibits and I didn't have anything set up right. I didn't have my list of exhibits, my index of exhibits, and I didn't have the exhibit dividers either. But as you can see, as you can see here, I had to include this or the document was not going to be filed. And in your state, make sure you look into this as well, just so that you get a heads up and you don't show up in the courthouse and try to file a document and get turned away. The next should be the actual exhibit itself, which is the interim order after case management conference. So I'm going to go ahead and stop here. And again, if you want to see my analysis on those 2 orders that I've included as exhibits, just watch those videos, part 16 and part 9 of the My Docket series. One thing I want to mention before I stop with this document is later on, a few years later, I decided, and I don't know if other attorneys do this or not, keep in mind I'm not an attorney, so I should have said I don't know if attorneys do this or not, but later on I stopped doing this. I stopped attaching orders as exhibits to orders or any other documents that were already filed as exhibits, and what I started to do instead was just reference them. It was just, in my opinion, the papers, they started to get bulkier and bulkier as I was including things that were already filed in the court case anyway. And as far as I know, it's not against the rules to do so. It didn't come back to bite me. It didn't blow up in my face. And I just started to reference, like if I needed to refer to an order that was entered, I would just reference the order that was entered and mention the specific date that it was entered. And that's one of the ways in which I cut down on exhibits. Now, if it's a filing or an order that's been entered in a completely different courthouse, that's different. You're going to want to actually include that as an exhibit. So, for example, if I had a document from California or a document from maybe even one of the justice courts, I would include that as an exhibit because I'm not sure if the district judge would be able to pull that up on his own. He might need to actually read the document before he can he just might not be able to pull it up if it's in a different courthouse or a different state entirely. So that should cover exhibits for this document. Taking a look at the affidavit of service of that motion. Again, another form document, fill in the blanks. I apparently served it on the 24th. Oh, and I didn't even mention how I served it. I left those lines blank. Oh, wait, here we go. Okay, I did. So I served her personally, which means I went to the law office and in person gave the documents that I filed to the staffer that was working at her office. I've talked about this before in several videos. When you start preparing custom documents, you'll typically include the certificate of service at the back or the last page of the document that you're filing, or at least close to the back or close to the last page. And since I'm not using custom forms, since I'm using SelfHelp Forms, I end up having to do all this extra work, fill out all this extra paperwork, and this is just one example of that extra work that I have to do. And here's the affirmation again, just letting the clerk know that this affidavit of service doesn't contain a social security number. Having gone through that motion, I did want to spend a little bit of time on what I think I could have done to really make it better. And initially, I thought it was going to be my first example of gotcha litigation. And if you don't know what I'm talking about, that watch my video, Gotcha Litigation, because it covers the idea that as soon as your ex makes any mistake at all, you need to go after him. And when I read through it, I realized I actually didn't do that. I mean, I could have made it a little bit better, but two of the big things that I did is, number one, I didn't act after the first violation. I told her, please comply with the order tomorrow. So that's a big thing when it comes to gotcha litigation and contempt of court, is that you don't go to court and say, yeah, my ex made this one small mistake and I'm trying to hold her feet to the fire on that. You know, with big mistakes, you can go to court on the first violation. Something like your ex didn't put them on the plane and so they missed their flight and didn't get to go to Disneyland. And so you wasted all this money on a flight and now your kids didn't get to spend Christmas with you at Disneyland. You don't need to wait for multiple violations to do something with that. But like showing up an hour late because she claims she's confused, even though I know she's not. Now, in hindsight, I had no idea about this. And even if I had, the court's going to find it plausible that she's confused. I didn't react on the first violation. She did it again a second time. And that shows that I kind of told her, you know, this is a problem, don't do it again. And she is being very willful and deliberate about what she's doing. The other thing that I did was I offered her a way out. I told her, you know what, fine, you're confused. At least give me an hour back, you know, on the drop-off. You know, when I'm gonna drop him off to you, or you can come pick him up an hour later so that I make up for the time. So those are two really strong moves in my favor that show that I'm not just trying to catch her on any random thing just to see her punished. I'm not trying to be vindictive. I'm not vengeful. I honestly want to work it out. That's what I have shown with those two things. What else could I have done to really help? I think I could have asked for makeup visitation in the motion. That would have been an opportunity for the judge to say, you know what, this isn't a very big deal. I'm just going to give you a couple of extra hours. Would I have filed this had I had the experience then that I have now? The answer is no. And the reason why is because you can't really force a judge to hold someone in contempt of court, at least not in Nevada. You can't appeal these orders. So the only way you can challenge a judge's refusal to hold your ex in contempt of court is through what they call a writ petition. If you haven't seen my video, writ petitions, please watch it. The Supreme Court and the appellate courts, at least in Nevada, a lot of these writ petitions, they decline to entertain, they decline to review. And that's just something that they're allowed to do. With an appeal, they can't do that. If you file an appeal consistent with the rules and the law, the appellate court must consider it. You're not necessarily for sure going to win, but they must consider it and they must say, yes, the judge was right, or no, the judge was wrong. You're going to get an answer as long as you file it consistent with the rules and statutes. With writ petitions, they have a third option, and that is the option of just saying, we're too busy. Not important enough. They're not saying the judge was right. They're just saying they don't have time for you. And that is it's a game changer with the approach as to how far do you want to take a certain thing. Because at the end of the road, you're not sure you're going to be able to get review from an appellate court anyway. And so she took an hour from my time, but I have a specific date, December 26th, that is going to trigger and totally change the way visitation works anyway. The best shot I had at getting any kind of relief was the makeup visitation, but 2 hours it could come off as petty. And my approach is, when you're representing yourself, it's especially important that you don't take as many risks. Lawyers can take more risks. Quite frankly, they can. It's their job. It's how they make a living. As a non-attorney, the lawyers and many of the judges are just itching for the opportunity to sanction you. That's the opinion that I have. And going through my 8-year-long high conflict child custody ordeal, my ex's attorneys requested I be sanctioned 7 times. And so it's given me a unique approach, I guess you could say, to only file something if you are sure you're going to win. Because if not, they're going to come back later and say, look, he filed that and he lost, and that and he lost, and he lost on that too. He lost on that. He is vexatious. He's just trying to harass the client, my client. You should sanction him. You should declare him a vexatious litigant. You should punish him. And so my experience now, after all these years, is to not take risks. And even though what my ex is doing is wrong, even though what the judge is going to do is wrong, you still end up having to work around it because you can't fix it. There are other areas of the law where I can file an appeal and force the judge to make the right decision by using an order reversing from the Supreme Court. And I do this 4 different times. I do this twice against, no, I do it once to this judge, and I do it twice to the new judge that takes over later on. And then I do it one more time to a completely different judge who's not even in the family division at all. So that's unfortunately my conclusion, and I hope that it helps my viewers. As hard as it is to accept, there are some situations where you can do the right thing. You can give your ex opportunities to rectify the situation, but the court is likely going to just see it as too small of an issue. You lost 2 hours, whoop-de-doo, who cares? You know, a good judge might say that's messed up. You're going to get 2 hours of your time back, or maybe even a full day, you know, just to teach you the other side a lesson. Don't violate the court's orders on purpose. But in this case, the judge doesn't do that. Now, again, there's a whole lot more that I can talk about that I'm itching to talk about, but I want to set that aside for the actual video that covers the order from the court. That being said, let's go into the aftermath. I filed the motion for order to show cause, but that filing did not require a filing fee, and neither did the affidavit of service, and so I incurred $0 in costs. My ex didn't file any documents with respect to this video, so she incurred $0 in costs as well. I didn't have an attorney, so I incurred $0 in attorney fees. My ex had an attorney who probably charged her, let's say, an hour, because not only would she have to read my filing, but she'd probably have to communicate with my ex, send an email, pick up the phone and call her. I'll round it out to an hour. Or we could even do 75 minutes, 3/4 of an hour, and then for the review of the proof of service, affidavit of service, we could say 15 minutes, which rounds it all out to about an hour. So if my ex's attorney charged her an hour to review this filing, that would come out to $250 in attorney fees. And as with all my previous videos, definitely post something down in the comments if you have any questions, and I will see you guys next time.